Good afternoon. This is Emily Sumner with Sumner Immigration Law, and we are here today to talk about the October Visa Bulletin. I hope that you're excited and that you have lots of questions that you can ask in addition to the ones that you submitted. If you can start by putting in the chat that you are able to hear me, that would be helpful. All right. We have one participant that says, good afternoon, can hear you. Awesome. Thank you for letting me know. So let's get started. The October 2021 Visa Bulletin, what does it mean and what can we expect next? So we're going to start by talking about what is the Visa Bulletin. Then what does it mean to have the final action dates and the next action date? The dates for filing, final action date and date for filing. Then we're going to look closely at the October Visa Bulletin, especially for India and China. We'll talk about what retrogression means and what happens when a priority date retrogresses. We'll talk about toggling categories between EB3 and EB2. I'll touch just a little bit on what some people are calling the new law, which actually is not a law yet and may not come to fruition, and then what to expect next. As we go through this webinar, please keep in mind that the information that I am providing today is for educational purposes only, and it is not legal advice. In addition, I would love for you to ask more questions. I want this to be interactive, so if you have questions, please put them in the chat as we go along, and I'm happy to answer them. If we have fact-specific questions that are unique to your particular situation, I'm not able to answer those in this particular forum. You would need to set up a time for a consultation for that. But if you have general questions, absolutely, please let us know. So what is the Visa Bulletin? The Visa Bulletin is published once a month by the Department of State, US Department of State, and it tells us generally when a green card is available for the family-based categories and for the employment-based categories. So if you look at the Visa Bulletin, you know that there are 4 tables on the Visa Bulletin each month. The Visa Bulletin is published, like I said, once a month. It's usually around the middle of the month, usually around the 15th of the month, sometimes a little before, sometimes after, or much later after, like it was last September. But it's published once a month, and like I said, tells us which categories, which green, tells us basically where you are in your place in line for a green card. There are 4 tables. There are 2 for the family-based category and 2 for the employment-based category. Within each of those categories, there is a table that says final action dates and another table that says dates for filing. We're going to be talking about the employment-based categories today and not touch really on the family-based categories. If you have questions, feel free to submit them and I'll get to them if I can about the family-based categories, but we're really focusing on the employment-based categories today. So if you look at the 2 tables under the employment-based section of the Visa Bulletin, there's a list of the preference-based categories. So EB1 generally is for aliens of extraordinary ability, outstanding researchers and professors, and then multinational transferees, executives or managers. EB2 is for positions that require a master's degree or the equivalent, which is a bachelor's degree plus 5 years of experience. And then EB3 is for positions that require either a bachelor's degree or 2 years of experience. EB3 also includes skilled workers, which just is 2 years of experience, and unskilled workers as well. And then EB4 encompasses all different types of categories, including religious workers and other categories. We typically don't have a lot of people who fall into that category. EB5 is for certain types of investor visas. So what is a priority date? When you look at the Visa Bulletin, you see these tables and you see the dates in these charts. Those dates are called priority dates. The priority date is the date that a labor certification is filed in the employment-based setting, unless a labor certification is not required for your particular type of filing, in which case it is set by the date that the I-140 petition is filed. So if we are filing a labor certification, for example, today, which actually we are, then the priority date for that particular case would be September 15th of 2021. It is possible, you probably know this, but it is possible to recapture to reuse priority dates. So for example, if you have an I-140 petition that was approved with a previous employer, you can port that priority date and use it in a subsequent filing. So it's not always based on the date that you filed this particular case with this particular employer. You can port a priority date from a previous employer. So what is this with the final action dates and the dates for filing? It is so confusing. It's confusing for immigration attorneys. It's confusing for individual employees who are going through this process, and sometimes for their employers as well. It is a confusing mess. This happened, the final action date versus dates for filing happened because if you remember, you may or may not remember that back during the Obama administration, he had a lot of immigration initiatives, and he's president, of course, so he's not able, or he was president, so he's not able or wasn't able to pass laws through Congress. He could support them and support Congress, but Congress is actually the one that creates the immigration laws, so he wasn't able to create laws on his own. But he took a lot of initiatives that were that were within the confines of the existing law. So he made changes or proposed changes that were within the confines of the existing law, and was able to have the agencies change some of the regulations. One of his proposals was for people who are waiting for a green card to be able to file to be able to submit the I-45 before their priority date is actually current. So that they can get the intermediary benefits like the advanced parole document and the employment authorization document, ultimately be able to port to other employers possibly. So it came from that proposal. This change happened, I'm going to call it the bifurcation of the visa bulletin, where you have the dates for filing and final action date. It occurred for the first time that we saw this was October of 2015. In addition, we had a situation previously, a couple of times, but in 2015 and previously in 2007, where the visa bulletin was published, and it had Department of State thought that they would be able to, they'd have visas available. So they said, okay, you can go ahead and file. These priority dates are going to be current soon, so you can go ahead and file. And then there was some disagreement with USCIS. I won't get into all of that, but just know that this bifurcation came about in October of 2015 for the first time. It's not enough to look at just one of the dates, the dates in either final action. You can't just look wherever you want, in other words, and like pick whichever date you want to use, whichever is better for your particular situation. Instead, we have to wait for the USCIS, if you're filing, this is if you're filing here in the United States, for the adjustment of status, or if you're wanting to do that, you have to wait for USCIS, the immigration agency here, to tell us if they are using the dates for filing or the final action dates for that particular month. So typically the visa bulletin is published by Department of State, and then usually within a day or two, USCIS will publish on their website whether they're going to use dates for filing or final action date for that particular month. It's important to note that this changes month by month. So it may be, and this happened now in September, USCIS said, okay, we're using for the month of September, based on that visa bulletin, they said you can use, I'm talking about employment-based, you can use only the final action date table. So if your priority date was current per the final action date, then you are able to file. For the month of October, it's different, and we have to go by the dates for filing table. So it can change from month to month. We can't just rely on what happened last month or last time you thought about it. You have to look every month and see which table their USCIS is going to accept. This does not play into consular processing quite as much. So it is possible to apply for I'm going to call it a green card, but you would apply for an immigrant visa at the US consulate overseas if you were living overseas, or if you traveled there to process your immigrant visa. And the use of the final action date and dates for filing isn't quite as important in that particular context. But I think most of the people attending this webinar have filed or are looking to file the I-45 here in the United States, and it's really important to pay attention to that. You don't want to file the I-45 based on the wrong table and have it rejected or worse, denied. So it's very important to pay attention to that. For the month of October, the USCIS has said that they are using the dates for filing. So it's the second table in the employment-based section. Also keep in mind, if you're thinking about a family-based case, keep in mind that USCIS will specify each month whether they're using the dates for filing or final action date for each category, for family-based and employment-based, and it's not necessarily the same. So they could say, we're using the final action date for family-based, we're using the dates for filing for employment-based, or vice versa. They can also specify by category, which they have done recently for the F2A category and the family-based. Just know that you have to look at the USCIS website to make sure that you're using the right table. So we're going to dive now into the October Visa Bulletin. What is happening with the October Visa Bulletin? I have created this table here that's kind of a summary of a comparison of the October Visa Bulletin and the September Visa Bulletin. Again, this is only employment-based, and you'll see that we're only looking right now at India and China. The dates, your place in line for a green card is determined by your country of birth. So if you were born in India or China, you probably, and you're going through the employment-based process, green card process here in the United States, you're probably acutely aware of this, that it's based on country of birth. There is something called cross-chargeability, where you can use the country of birth country of your spouse if they were born in a different country, and we've had clients do that before, but know that it's based on the country of birth. You'll see on this particular chart, we have not included the rest of the world, so all chargeability areas except those listed, because those dates are current. That doesn't mean your green card is going to be approved immediately, as you probably know if you have already submitted the I-45, but it does, we haven't included that because it's current. So I'm really focusing here on the priority dates and how they have changed from September to October, and then also comparing the final action date with the dates for filing. So let's look at China first. The final action date in EB2 for China is the same for September and October. The dates for filing, and remember that in the month of October, USCIS has told us we have to use the dates for filing for employment-based. For the dates for filing, the date is September 1st of 2018. It's the same as the dates for filing from September, but these dates that are highlighted are the ones that we used for filing. So in September, we had to use the final action date. In September, the I'm going to say current priority date in September for China EB2 was July of 2018. Now the quote unquote current priority date, meaning if your date is before this date, you can file the I-45 for October, is September 2018. So it's moved up a few months, not tremendously, but a few months. Likewise for EB3 for China, the final action date stayed the same from September to October. For EB3 China, it advanced a little bit it retrogressed. Numbers are hard, months are hard, calculations are hard. It retrogressed. It was July of 2019, and now it's January of 2019. So that should say retrogressed. However, it did advance, and this is why I put advanced, because it advanced a little bit from September. So in September, if your priority date was before January 8th of 2019, you could file if you were born in China for EB3, and now if it's before January 15th, so it's advanced literally a week relative to, again, we're talking about the dates that you can file. Looking at India, the EB2 final action date stayed the same. The dates for filing advanced significantly, and it advanced significantly from the date that we had to use for filings in September. So we do see some significant movement in India EB2, and we'll be talking about that again in a few minutes. EB3 India, same for final action date, and then it retrogressed. If you compare the dates for filing from September to October for India, it retrogressed a couple of months, but it advanced again about a week from September to October if you are comparing the dates that you had to use to file. This is super confusing. If you're super confused right now and you're thinking, oh my gosh, I have no idea what Emily's talking about, you're not alone. Don't worry about it. Know that this is why I have a job. This is why immigration attorneys exist, so that we can help you navigate all this depending on your particular individual facts. The bottom line here is that there was not a tremendous amount of movement overall with the October visa bulletin. I personally am not surprised about that. I follow Charlie Oppenheim, who's I call him the man behind the curtain at Department of State, who allocates the green card, the visa. When I say visa, I'm talking in this context, I'm talking about green cards, but he allocates the visa usage. He gathers data from the Department of State and USCIS. That's incorrect. He doesn't allocate them, but he gathers the data from USCIS and Department of State and determines what the priority dates should be on the visa bulletin each month. So I follow him, and based on what he has said for the past several months, he's indicated that there wouldn't be tremendous movement in October, which is tremendously different from last year. If you remember last year, especially for India and China, there was tremendous movement. We could use the dates for filing, and a lot of people could file, which was exciting. But I think this tells us that a lot of people filed. I have heard from different liaison meetings and notes that the USCIS received a lot more filings. The volume of filings was higher than they anticipated. So they are anticipating, they're still working through those cases. Some have been approved, some not, obviously, but they're having to work through those cases to use up these numbers. So that's the reason that it hasn't advanced tremendously. It is interesting, I think, that the dates for filing have retrogressed for, if you look at the dates for filing for EB2 for India and China, those dates have retrogressed a bit and stayed the same for China. I think that's telling, and I think that's probably what we're going to see for the next few months. I think it's possible that we could see some further retrogression. We'll have to see what happens with the visa usage. And Charlie Oppenheim is amazing. If you don't follow him on YouTube, I highly recommend it. He has meetings that are, or rather YouTube sessions, I guess. My 13-year-old could tell me what the correct term is, but he has YouTube posts once a month where he talks about what to expect and what's happening, what's going on, how he came to these conclusions, and it's really helpful. I would recommend that you follow that if you don't already. So retrogression, what happens if your priority date retrogresses? And if you have, I just pulled up the chat. If you have questions as I go along, please feel free to put them in the chat. So retrogression means that the priority date, your priority date was current, meaning you had the ability to file the I-45, hopefully you did, and then the date retrogresses. It goes back, like we saw a minute ago with the dates, and you are no longer able to file for the I-45. Hopefully you've already filed, so it's not a big problem, but what happens if the date retrogresses? What happens with that I-45 that you filed? It remains pending. So let's say that in September, for example, and I'm just using this as an example, so September of this year, September 2021, you filed the I-45, and then down the road in December of 2021, again, just making this up, nobody has a crystal ball and knows what the dates are going to do, but in December of 2021, the dates retrogress, and your date is no longer current. What happens with that I-45? It remains pending with USCIS. In theory, USCIS will still process the case and have it ready to go before your priority date becomes current again. They don't provide a lot of insight onto how they prioritize their work, how they process these I-45 cases that are pending. But in theory, they would continue to work the case. They would continue to issue the EAD, the employment authorization document, and the advanced parole, which is the work permit and the travel document, while it's pending. So it would be, my understanding is they work the case as much as they can, and then they put it to the side until the priority date is current again. Now, a lot of times what we see is when the priority date is current again, we will receive a request for evidence asking for an updated medical exam or the medical exam at all, if the medical exam has not been filed yet. Sometimes we receive a request for evidence asking for an updated I-45J, which is documentation. It's a form that confirms that you're still working with the same employer or that you're able to port to a new employer. So don't be surprised if you receive a request for evidence. That's actually a good sign that they're close to the point of finally adjudicating your case. Also keep in mind that the priority date has to be current per the final action date chart in order for the I-45 to be approved. So if your priority date is current per the dates for filing chart, that's great. It's an indication that it probably, hopefully will be current soon, that USCIS cannot approve your case if your priority date is only current per the dates for filing. It has to be current per the final action date. Oops. Okay, so retrogression, should I stay or should I go? I have seen this a little bit already with the October visa bulletin coming out, and I think it's probably going to happen more frequently in the coming months, especially for those individuals born in China. I think it's we're going to see situations where a person has filed an I-140 petition, EB3 I-140 petition, frequently called a downgrade, meaning they had an EB2 I-140 petition that was approved, pending, but the priority date wasn't current. Last year, October 2020, they were able to file the I-45 in the EB3 category, so they filed an EB3 I-140 downgrade. That's pending, and now with this October visa bulletin, or perhaps in the future, their EB2 date is actually current per the final action date. So I think that's going to happen, like I said, more frequently than we've seen in the past. What do you do in that situation? So it is possible in that situation, right? As things stand right now, if you are in that situation, if you filed an EB3 I-140 petition and you filed the I-45, you would have to interfile. That means you want to let USCIS know that you want your I-45 attached to the EB2 I-140 petition instead of attached to the EB3 petition. That does not happen automatically. USCIS does not look around their inventory and see, okay, this guy's EB2 I-140 is current. Does he have a 485 somewhere attached to some filing? It does not happen automatically. It is a messy process to do. This interfiling, there's no form for it that's available. And when there's no form with USCIS, it is a mess. The process is that you have to have the EB2 I-140 petition approved. So it can't be just pending, it has to be approved. And the priority date has to be current per the final action date. So if those two conditions are met, then you can contact USCIS and ask them to attach the I-45 to your EB2 petition instead of your EB3 petition. By contact, I mean write a letter to them, call them, chat with Emma, all the ways that you can think of to, an immigration attorney can help you with this if you have one on file. I will say I will not do this for individuals that I don't already represent. It's very difficult to have the G28 recognized if you're not already the attorney of record. So if I am your attorney right now and you are in this situation, let me know and I'm happy to give you individual advice. But if I have not represented you previously, I won't do it because it's just a huge headache to get the G28 even recognized. So USCIS will talk to me. I really recommend that you stick with the attorney that you filed with originally if you need to do an interfiling. It's in your interest because it would take a long time just to get the G28 recognized. But anyway, that's the process. You write a letter, you email them. Sometimes it requires congressional intervention. It requires a lot of persistence to get this done so that the I-45 is moved to your EB2 I-140 petition instead of EB3. So what if you do that and it takes at least a few months to do that, and then the EB3 date is current again? Then you would have to go through that process over again to have the I-45 moved back to the EB3 petition. So it is not an easy process. It's one I really recommend that you talk to a qualified immigration attorney before you decide to do that, because if it reverses again, you could spend a lot of time toggling back and forth, and that's not an efficient use. You want to make sure that you have the I-45 attached to the one that you think is going to be current soonest, which no one can predict. It's a tough situation for sure, but definitely talk to a qualified immigration attorney if you're in that situation before you try to take action, because you don't want to be in a situation where, like I said, the EB3 date moves up again, like the next month. It's a tricky situation, very challenging, but that's what you would do. You would interfile. So changing employers a lot. Let's talk for a minute about I-485 processing time. This applies to everyone, regardless of the country that you were born in. The I-485 processing times are ridiculously long right now. As you probably know, if you have the I-485 pending, we have several cases that have been pending for over a year. We've had some that we filed last October that have been approved. The vast majority still are pending, even though their priority dates are current. In other situations, we've had cases that have taken 18 months, close to 2 years to be approved, employment-based cases. So it's a long wait. The same is true for the employment authorization document, the EAD, and the advanced parole. We still have some cases that we filed last October where those are not approved. And it's very, very frustrating for us, and certainly for the individuals who are waiting for these immigration benefits as well. So bottom line is processing times are ridiculously long. USCIS they post on their website what the processing times are for different types of filings. And you can look them up, it's publicly available. The challenge is if your case is within posted processing times. So in other words, if USCIS says, okay, for this particular type of case pending at the service center, it takes us 60 months, yes, 60, to process, they won't let us place a service request. A service request is when we, as the attorney of record, or you can do it, but and it's good to communicate, if you do it, communicate with your attorney, because you can only place one at a time, and you have to wait a certain period of time before you submit another. So keep those lines of communication open if you decide to do it on your own. But my point is that if the case is within processing time per USCIS, they will not allow us to place a service request. That means we have no recourse to follow up with them. You could possibly seek congressional intervention. I really don't like to do that unless it's a life or death situation, because they're so busy with cases. And we want to, people who do have a true emergency, we want them to be able to help them. But it's a very, very frustrating situation. So this brings us to the next topic, which is changing employers. Can you change employers while the I-485 is pending? The answer is yes. This is called I-485 portability. Not to be confused with H-1B portability, similar idea, but not quite the same situation. In order to port your I-485, the I-140 petition has to be approved. That's kind of a gray area. There are some immigration lawyers who say, no, it's okay for the I-140 to not yet be approved. I don't recommend that. The language is that the I-140 petition has to be approvable. And you don't want a situation where you port and then the I-140 is denied and then you're out of luck. So I recommend that the I-140 petition be approved. That's the best practice. You have to change to the same or similar type of employment. So there's no career changes that are allowed here. By career changes, I mean, and same or similar, I mean, it's basically the same occupation. USCIS understands that a person will hopefully have wage increases over time. You'll have salary increases, that you may have increased responsibility over time, but you can't change from a computer software engineer to an accountant, for example. That would not be the same or similar. In addition, the I-485 has to be pending for 180 days or longer before you port. If you meet these requirements, and please, please, please get a detailed consultation from a qualified immigration attorney before you decide to do this or to try it. But if you meet these requirements, then you should be able to port to the new employer, meaning change jobs, without having to start the green card process all over again. So meaning you don't have to file a new perm labor certification, you don't have to file the I-140 petition over again. The mechanism for letting USCIS know that you're doing this is filing what's called the I-485J, which is a form that you file with USCIS. You can do that at the time that you change employers, or USCIS can issue a request for evidence before they approve the green card and ask for this I-485J, at which time you would let them know that you've changed employers and that you still meet these requirements. That being said, so yes, it is possible to change employers. However, my general recommendation, there are exceptions, but my general recommendation is to maintain non-immigrant status, meaning your underlying H-1B or L or E or whatever status it is that you had prior to starting this process. My recommendation is to maintain that until the time that you get the green card, if it's possible. Sometimes it's not possible. Sometimes you, for example, on an L, you would meet the 5 years or 7 years, and you're not able to extend further. So it's not always possible, and that's okay. But my general recommendation is to maintain, because if, heaven forbid, something happens with your I-45 and it's erroneously denied or correctly denied, you could be in the US without your underlying status. You may be able to get it back again, but not without jumping through a lot of hoops, and that's not guaranteed. So I recommend that as a safety net, just in case something goes awry with the I-485. You can use the EAD. So once you get the employment authorization document or the work permit with the I-485, you can use it instead of maintaining your non-immigrant status. You can't have both. You can't maintain H-1B status, and this again is a gray area, but in my analysis is you can't maintain H-1B status and use an EAD based on the I-485 filing. That would be a violation of your H-1B status. Using the EAD is an advantage. It gives you an advantage because you do have, just checking the time here, you do have the flexibility to move to a different employer if you meet these requirements. One person has a question, I-485 pending 180 days or longer from which date? From the date that you file the I-485. So what is coming next? The dates may retrogress in the coming months, and I base this off information that I have heard from Charlie Oppenheim. No one knows for sure. So several of the questions that were submitted for this webinar were, what do you think about the dates becoming current for India EB2 for October 2017 with that priority date? Nobody knows. Charlie Oppenheim himself is not able to answer those questions, that particular question. It really depends on the number of on visa usage, on how many green cards are used between now and the time that priority date approaches getting current. So even Charlie can't answer that question, how long it will be. In general, Charlie has said, I've heard him say that 2015, 16, 17 dates for India probably will not be current within the foreseeable future. So that's just something to keep in mind. We're probably going to see about the dates that we're seeing right now for the foreseeable future. The dates may retrogress. Charlie has said that as well, that he may need to establish some cutoff dates and or retrogress the dates based on visa usage. Again, depends on what happens, how many green cards are used up. USCIS is pre-working cases, supposedly, to be ready to approve. So they do not, we talked a little bit about this when I talked about the dates retrogressing and what happens then, but they do not, if you submit the I-485 and the dates retrogress, they supposedly don't let it just sit on a shelf. They supposedly work it as much as they can so that when the date is current or is close to being current, they can finish their final steps to approve it. The medical exams, we get lots and lots of questions about medical exams. It's confusing, I know. The medical exam is when you obtain the medical exam. If you have not yet filed the I-485, it is valid for 60 days. That means when you get the medical exam, you have to file the I-485 within 60 days of getting the medical exam signed. If you have already filed the I-485 and you have not yet submitted your medical exam, you can obtain the medical exam now if you want to. The medical exam is generally valid for 2 years. I know that USCIS recently announced that medical exams will be valid for 4 years. However, there was a bottom bullet point on that announcement that said that this applies to cases that are approved before September 30th, 2021. They may extend that. They may make it so that medical exams are valid for 4 years indefinitely, but they have not done that as of yet. So right now, medical exams are valid for 4 years only if your case is approved before the end of this month. Otherwise, the medical exams are valid for 2 years. So if you want to go ahead and have the medical exam done, if you haven't already submitted it, you can, so that you'll have it ready to go. But keep in mind, it's only valid for 2 years. So if your priority date is, if you were born in let's say India, and your priority date is 2015, 16 later, then you may want to hold off on getting the medical exam. I leave that to you. I never make those decisions for clients, but it may expire before you're actually able to use it. Lots of people want to send in the medical exam proactively to USCIS. I totally get that. I love being proactive. However, if you send in the medical exam, it probably will not get matched to your file. It will probably sit in the mailroom and not ever get used. And then you may have an RFE for it again. The exception to that is if you get a request for evidence, of course, send it in, as indicated by USCIS. The request for evidence will have a barcode on the front of it that will allow the officers, or the people in the mailroom, rather, the contractors, to match up the medical exam to the actual file. Sometimes people want to create barcodes. There's barcode generators online. Sometimes people want to have a cover letter and put the barcode on that and send it in and hope it gets matched to the file. If that's something you want to try, go for it. Just know it may not work. And definitely communicate to your attorney if you try to do that. We want to know what's going on for sure. Keep us updated. Another thing that you should know about medical exams, if you have not had it done yet, is starting October 1st, in order to have the medical exam completed, you will have had to have completed all of your required vaccinations, COVID vaccinations. So if you're getting Moderna or Pfizer, or any subsequent ones that come out that are approved and that have 2 or more doses, you'll need to have both of those doses completed. Again, that's for medical exams that are completed on October 1st or later. So keep that in mind if you have not had your medical exam done yet. Also keep in mind that you have to have an approved perm to file the I-140 or I-485. I know that seems obvious, but it happens more than you would think, that a person has an approved perm and or I-140, and then they change employers. They're not able to file the I-485 yet. They change employers, they don't start the green card process, as soon as they're hired for whatever reason. Sometimes companies have policies about that. There are different reasons, and it's fine. But just know that if you're in that situation where you have a previously approved perm labor certification and even a previously approved I-140 petition, you cannot file the I-485 based on those approvals unless you intend to go back to that employer. If you intend to stay with your current employer, you have to go through the perm labor certification process again and have the I-140 petition approved. Remember, you may be able to port the priority date, which would be helpful, but you have to go through that process. So even if you think, oh my gosh, my priority date is years away, I'm going to be retired before it actually becomes current, go ahead and start the process as soon as you can, the employment-based green card process as soon as you can, because you don't want to be in a situation where all of a sudden your date is current and you're not able to file the I-485 because you don't have the new perm and I-140 approved. And then finally, in the new law, I've gotten a couple of emails in the past several days from clients asking about the Judiciary Committee's, the House Judiciary Committee's budget resolution. I'm not going to go into a lot of detail about that because it contains a lot of different provisions, but it does contain provisions for possibly allowing people to either file the I-485 sooner or obtain green cards sooner. That is nowhere near passage right now. That has to, it's possible that will be taken out when this particular bill is signed into law. So I'm not answering a lot of detailed questions about that right now because I've practiced for 16 years now, and I've seen situations like this many times before where there's a really hopeful piece of information or clause and a piece of proposed legislation, and then it doesn't come to fruition. I'm not saying it won't. That would be tremendously exciting. That would be fantastic for so many of our clients, and I'd be so excited. But right now, that's not near the point of being passed into law. So if and when we come closer to that point, we will definitely put lots of information out about that to educate our clients on social media, our blog posts, our email newsletters. But for right now, there's not any pertinent information about that at this point. bonus tip, and we're coming close to the end, so if you have additional questions, please feel free to put those in the chat and I'm happy to answer them. But here's the bonus tip that a lot of people either don't know or don't think about, and that is, if you are in H-1B status, you probably know that you can extend the H-1B status beyond the 6th year if you're in a certain point in the green card process. Namely, if you have filed the labor certification at least 1 year before, 365 days before the end of the 6th year, or if you have an I-140 petition approved. However, in order to keep extending the H-1B status beyond the 6th year, you have to file the I-485 within 1 year of the priority date becoming current per the final action date. And then the clock resets if the priority date retrogresses. So just keep that in mind. You don't want to be stuck in a situation where for some reason you're not able to file the I-485. Again, going back to what I said before, if you change employers, you have to have that perm and the I-140 approved with that particular employer, unless you intend to go back to the original employer. But you don't want to be in that situation where you're not able to file the I-485 for some reason, and you're not able to file the H-1B. All right. Again, if you have questions, put them in the chat. Otherwise, we're going to wrap up now. Please, please, please stay in touch with us. We will have lots of information forthcoming as things develop with the October Visa Bulletin, or rather the Visa Bulletins going forward. We know all there is to know at this point about the October Visa Bulletin, but we share updated immigration information through our blog posts, through social media, and through our email newsletters. If you are not already on the email newsletter, please feel free to sign up for that. You can sign up on our homepage, sumnerimmigration.com, and we will add you to that email newsletter that goes out once a month. We have one question before we wrap up, a couple of questions. Was this recorded? Yes, this is recorded, and we'll be sending it out to everyone who signed up. Another question, did the October Visa Bulletin include the family-based spillovers? Yes, it should have, according to the current statute. So that is a complicated calculation, and I believe that Charlie Oppenheim will probably be talking about that in his next YouTube session. But yes, it should, unused numbers from the family-based category should spill over. There was a situation, as you probably know, in the fiscal year that's ending September 30th of this year. So the new fiscal year for USCIS starts October 1st of each year. And there was a situation where there were about 100,000 unused numbers on the employment-based categories. Those will go unused. If USCIS does not adjudicate all 100,000, and they won't at this point, those will go unused, but unused family-based cases will spill over. For how long after EAD expires can someone continue to work? Okay, if the EAD expires, how long can you continue to work if the green card EAD extension is pending with USCIS? As long as you file the extension before the current EAD expires, you can continue working for up to 180 days. There's an automatic 180-day extension on the EAD. My priority is EB2 June 2020. What country is that? Priority EB2 June, sorry, not, okay, India. I should have known because China's current and everything else is current. June 2012, I have an L1A now. Should I wait for a downgrade or file an EB1? That's a question that you should talk to an immigration attorney about. It, of course, depends on the strength of your EB1 case. And it depends on where you are in your L1 status, how long you have left. There's several factors to consider there. And I can't give legal advice through this form, but definitely talk to an immigration attorney about that. That's a great question. When will we officially know how many green cards went unused? September 30th or next Visa Bulletin? I would imagine, so we have to wait until at least September 30th, and they're not going to have that information soon. I hope that they are public with that information. I know there'll be a lot of pressure from stakeholders like me and you and other people applying for a green card and their employers to know that information, but I don't know when we'll have that information. I would imagine sometime in October, but I don't know. I don't think they're going to be very eager to announce that because they should have used up those numbers. Do you expect EB2 to move forward by much more, and how to move forward and by how much? Do you expect EB3 to retrogress? I don't know the answer to that. You know, no one, I was saying earlier, and you may have joined late, which is fine, but no one, including Charlie Oppenheim, has a magic 8 ball, or I mean, we do, but they're not valid. But you know, what am I trying to say? Crystal ball to predict the future. But based on this information from the October Visa Bulletin, based on how little movement we saw, if any, I would say, and we also saw some retrogression in this Visa Bulletin, depending on which categories you're looking at. I would say I don't expect a lot of forward movement in the foreseeable future. That I could be totally wrong. I hope I'm wrong. But I don't think that we'll see a lot of forward movement, and we could see some retrogression either in EB2 or EB3. Again, check out Charlie's YouTube sessions because they're tremendously helpful. That's where I get my information. I don't know about EB5. I don't practice EB5. And you know, how do I know which office is processing my I-45? That's a really good question. So it should be on the receipt notice. The receipt notice should say it will start with letters. So SRC is Texas, and it'll tell you on the receipt number which service center is processing, or which service center originally got your I-45, but sometimes they're transferred. So they can be transferred to the National Benefit Center. They can be transferred to a local field office for processing, even a field office that's not local to you. They can go there for processing just to work the case. So it's really hard to know where it's going. But if you're looking at the processing times, if you're asking to look at because you want to look at processing times, I would start by looking at wherever you filed. And the ones that we filed mostly are in Texas, but again, look at the receipt notice. How long is I-140 processing taking? A long time. So premium processing is available for the I-140 petitions. So obviously, if you use that, if you pay an additional $2,500, the government will make a decision within 15 calendar days or issue a request for evidence. But otherwise, the I-140 petitions are taking at least 6 to 8 months, sometimes longer, especially we're seeing for the cases that were filed in October 2020, it's taking longer than that, sometimes closer to a year. I'm checking to make sure I haven't missed anything. And if you have questions, feel free to keep putting them here. One thing I want to mention while we wait a minute to see is I-140 available for EB1? Yes, it's available for some categories of EB1, namely the aliens of extraordinary ability, and I believe for outstanding researchers and professors, but not for, last I checked, it was not available for EB1C, which is analogous to the L1, which is the multinational executives or managers. One thing I want to tell you all before we wrap up and while we're waiting for any other questions, is the reason that we saw this tremendous forward movement in priority dates. I think you all know this, but the reason we saw this tremendous forward movement in priority dates in October of 2020 is because of COVID. Just like everything, right? Because of COVID, I'm waiting for tennis shoes and they're not going to be delivered for a long time because of COVID. Anyway, because of COVID, the US consulates around the world were closed. And so a lot of the family-based cases that otherwise would have been processed were not processed. And those numbers flowed down. The unused numbers went to the employment-based cases for the new fiscal year in 2020. The consulates, US consulates are reopening-ish. It really depends on the consulate, but we are seeing that family-based cases are being processed. So I think we'll see less of this. We'll see more numbers being used in the family-based categories than we did in 2020. How long is green card EAD processing taking these days? Anywhere from a couple of months to forever is what I would say. It's what we're seeing. We did, in all seriousness, we have had EADs that have been processed in literally 2 or 3 months. And then we have others that are still pending that we filed in October of 2020. How complicated is address change after filing the I-45? Is it a routine process or is there some risk? I'm not aware of a risk. In fact, you're required. Everyone who is not a US citizen is required to file a change of address within 10 days of moving. And it's straightforward. You do that on the USCIS website by using the form AR11, and you put in your new address and your old address and your new address. And that's really, really important to do, especially if you have the I-45 pending or any other immigration benefit pending, because USCIS will send things like your green card or your work authorization document to your address, and you want to make sure that that's updated on time. Risk as in the perspective of logistics, it's not difficult to do. I guess every now and then it doesn't take, you submit the address change and then either USCIS doesn't change it for some reason, or more likely they change it, but then they've already sent you your green card or your employment authorization document to the old document or to the old address, and then it's hard to retrieve it and get it sent back and everything. But otherwise, it's not difficult to do. Somebody said their I-45 receipt number starts with MSC. That's the Missouri Service Center, which processes, it's like a central processing place for I-45s. What happens to filed I-45 if EB3 dates change? Oh, thank you so much. Someone said that's a 5-star session. Thank you so much. I appreciate that. If the I-45 EB3 dates change, I think you're asking if they retrogress. Then in that case, the case will be processed, supposedly. USCIS will process the case as much as they can, and then it'll be put on hold until closer to the time that the priority date becomes current. But they should still process the I-45, the EAD, and the advanced parole. All right, we're going to wrap up now. I hope that you will follow us on social media where we post regular updates as well. If you have future ideas for future webinars or other information videos, we post on YouTube regularly now. If you have topics that you want to hear about, if you have questions, please, please, please email those to us or submit them by social media, by direct messaging us, or email us at info@Sumner Immigration. We want to know what you want to know, because that's really helpful for us to be able to help you. So please let us know what you want to know about, what questions you have, and we are happy to help. Thank you so much for attending. I hope that you will join us again next time, and have a great afternoon.